Good evening and welcome. Tonight we navigate the complex constitutional tightrope. Do stricter gun control measures indeed violate Second Amendment rights? Joining us are two distinguished experts. Professor Alistair Finch, a proponent of comprehensive gun safety legislation, and Ms. Cassandra Thorne, a staunch defender of Second Amendment freedoms. Our objective this evening is to foster a sophisticated and respectful discourse on this deeply divisive, yet profoundly important, national issue.
Thank you, Dr. Hayes. The Second Amendment undoubtedly guarantees a right to bear arms, a principle affirmed by the Supreme Court. However, it is crucial to recognize that no constitutional right is absolute. All are subject to reasonable limitations, a cornerstone of our jurisprudence. Historically, the phrase "a well-regulated militia" suggests a civic purpose, not an unfettered individual entitlement, particularly when juxtaposed with the arms of the 18th century versus today's advanced weaponry. The legal doctrine of quote, balancing interests is paramount here, compelling us to weigh individual liberties against the state's undeniable and compelling interest in preserving public safety and societal order. Indeed, pivotal Supreme Court rulings like Time District of Columbia versus Heller and *New York State Rifle and Pistol Association, Incorporated versus Bruin, while affirming an individual right, explicitly acknowledge the permissibility of long-standing prohibitions and regulations on firearms. These precedents do not preclude, but rather accommodate, sensible gun safety measures. Therefore, we contend that measures such as comprehensive universal background checks, bans on assault-style weapons and high-capacity magazines, and the implementation of red flag laws are not abrogations of rights. Instead, they are constitutionally permissible, indeed necessary, instruments to curtail the devastating epidemic of gun violence that plagues our nation, without disarming responsible citizens wholesale.
Dr. Hayes, Professor Finch, thank you. The Second Amendment is not merely a suggestion or a historically constrained clause. It is an unequivocal, fundamental individual right. Its primary purpose, as robustly affirmed in the *Heller decision, is self-defense, an inherent right that predates the Constitution itself. Interpretations seeking to narrowly confine this right to active militia service fundamentally misunderstand its historical underpinnings and its broader scope for personal protection against all threats. The framers, deeply wary of potential governmental overreach, enshrined this right to ensure that the citizenry would remain a bulwark against any nascent tyranny, a principle as relevant today as it was then. Many, if not most, of the so-called stricter gun control measures currently proposed are demonstrably overbroad. They disproportionately penalize law-abiding citizens, who are not the source of gun crime. Furthermore, these measures often prove ineffective against individuals with criminal intent, who, by definition, do not adhere to the law. To impose such restrictions is a direct infringement, and the text says shall not be infringed, upon a constitutionally enshrined liberty. Paradoxically, these well-intentioned but misguided efforts risk rendering responsible individuals more vulnerable, not less, by impeding their ability to defend themselves and their families.
Ms. Thorne's passionate defense of self-defense and her emphasis on, quote, infringement are understandable, yet they tend to overlook critical distinctions within constitutional law. There is a profound difference between reasonable, narrowly tailored regulations designed to enhance public safety and any notion of systematic disarmament. The former is a legitimate, indeed essential, exercise of governmental power. To suggest the framers would have countenanced no regulatory evolution in the face of firearms possessing such unprecedented destructive capacity as we see today strains credulity. The imperative of public safety, a core responsibility of any government, necessitates a dynamic interpretation of constitutional tenets to effectively address modern societal perils, including gun violence. Furthermore, many legislative efforts are specifically aimed at closing dangerous loopholes, such as the private sale exemption for background checks, which are demonstrably exploited by those who illegally acquire firearms and should not possess them.
Professor Finch speaks of balancing rights and adaptable interpretations, but one must exercise extreme caution. Historically, the invocation of quote, public safety has, at times, served as a convenient pretext for the incremental erosion of fundamental constitutional protections, a slippery slope we must vigilantly guard against. The Second Amendment's significance transcends mere recreational use or sport. It is a critical check on state authority, a guarantor of individual liberty against potential overreach. Regarding the empirical efficacy of stricter gun laws, one need only look at jurisdictions with the most stringent regulations, yet which continue to suffer from high rates of gun violence. This suggests a fundamental misdirection of focus, away from addressing root causes such as untreated mental health crises, deep-seated socioeconomic disparities, or, crucially, the inadequate enforcement of the multitude of existing firearm statutes.
Professor Finch, Ms. Thorne compellingly argues that many proposed gun control measures disproportionately penalize law-abiding citizens. What constitutional safeguards and practical mechanisms can ensure that stricter controls effectively target illicit firearm acquisition and misuse, without imposing undue burdens on responsible gun owners?
Dr. Hayes, the key lies in precision and due process. Measures like enhanced background checks for all sales are not burdensome to the law-abiding, but are critical for stopping prohibited purchasers. Red flag laws, when properly implemented with robust due process protections, allow temporary removal of firearms from individuals demonstrably posing an imminent threat to themselves or others. A targeted intervention.
Ms. Thorne, acknowledging the pervasive and tragic issue of gun violence, if not through enhanced legislative controls, what specific, constitutionally sound, and actionable strategies do you advocate for? How can we meaningfully address this public safety crisis while unequivocally upholding Second Amendment prerogatives?
Dr. Hayes, our focus must be multifaceted. Firstly, robust enforcement of existing laws is paramount. Many crimes are committed by individuals already prohibited from possessing firearms. Secondly, we need massive investment in mental health care infrastructure and proactive community-based violence interruption programs. These address root causes, not just symptoms, and fully respect constitutional rights.
Professor Finch, how do you address the argument, often raised by Ms. Thorne and others, that the primary focus should be on enforcing existing laws more rigorously, rather than continually enacting new ones?
While robust enforcement of current laws is undeniably essential, it is not mutually exclusive with enacting new evidence-based legislation to close glaring loopholes that criminals exploit. Existing laws, for instance, often don't cover private gun sales adequately, creating a highway for firearms to enter the illicit market. New laws can address such deficiencies without hindering lawful owners.
Ms. Thorne, considering the dramatic evolution of weaponry since the 18th century, how does an originalist interpretation of the Second Amendment adequately account for firearms with capabilities far exceeding anything conceivable to the framers?
The core principle of the Second Amendment, Dr. Hayes, is the right to effective self-defense. The framers understood that technology evolves. They didn't limit the First Amendment to quill pens. The right is to arms in common use for lawful purposes, and the type of arm should be sufficient to counter contemporary threats, preserving the fundamental right to self-preservation.
Professor, Ms. Thorne mentions arms in common use. How do you define that in the context of, say, semi-automatic rifles, often termed assault weapons?
The term assault weapon itself is often a political rather than a technical designation. However, firearms designed or easily modified for rapid, widespread casualties, with features like high-capacity magazines, arguably fall outside, quote, common use for civilian self-defense, and into a category that can be legitimately regulated more stringently for public safety.
But, Professor, millions of such rifles are lawfully owned by responsible citizens for sport, collection, and self-defense. Labeling them as such is a path to banning commonly owned firearms, which Knopfler expressly cautioned against.
The Heller decision also affirmed the legitimacy of prohibiting, quote, dangerous and unusual weapons. The debate lies in whether certain modern firearms, due to their lethality and military-derived features, cross that threshold, irrespective of ownership numbers.
And who decides what is too dangerous or unusual? This opens the door to arbitrary restrictions based on fear rather than fact, disarming the law-abiding while criminals remain unaffected.
In summation, it is imperative to reiterate that constitutional rights, including those enshrined in the Second Amendment, are not absolute. They have always been subject to reasonable limitations, particularly when the collective well-being and public safety are demonstrably and significantly at stake, as is the case with rampant gun violence. Judiciously implemented, evidence-based gun safety regulations, such as universal background checks, restrictions on weapons of war, and red flag laws with due process, represent a constitutionally sound and morally necessary approach to mitigating this crisis. We must not ignore the explicit, well-regulated component of the Second Amendment, which underscores a communal aspect and the inherent responsibility of a civilized state to protect its citizens from preventable harm. Ultimately, our path forward requires evidence-based policymaking that transcends rigid ideological entrenchment, striving for a judicious, life-saving equilibrium between cherished individual freedoms and our indispensable collective security.
To conclude, the Second Amendment stands as an indispensable individual right, foundational for self-preservation against all forms of threat, including, critically, the historical specter of potential governmental overreach. Many proposed stricter gun control measures, however well-intentioned, are fundamentally flawed. They are largely ineffective as deterrents to criminal behavior and primarily serve to penalize, disempower, and disarm law-abiding citizens. We must issue a resonant caution against the insidious, incremental erosion of our constitutional liberties, often advanced under the emotionally compelling but dangerously expansive guise of enhancing public safety at any cost. Instead, our focus should be resolutely fixed on robustly enforcing the extensive laws already on the books, comprehensively addressing the multifaceted root causes of violence, such as improving mental health care access and tackling socioeconomic drivers of crime. And above all, we must consistently uphold the rights of responsible, law-abiding individuals to own firearms for their protection, a right that shall not be infringed.
My sincere gratitude to Professor Alistair Finch and Ms. Cassandra Thorne for their erudite, passionate, and vigorous participation in this crucial discussion. Tonight, we've explored the central dialectic, the intricate, often fraught balance between individual constitutional rights, specifically the Second Amendment, and the collective societal imperative for public safety. The divergent interpretive approaches to this amendment underscore the profound complexities involved. We encourage our audience to engage in continued, informed reflection on these vital issues. Thank you for joining us. This concludes our broadcast.